Together with my colleague, Mr. Sebius Christians, and we are ready to proceed. As the court pleases. My name, my lady, it's Ngakumbirwe Kashivena from Kashara Incorporated, my lady. Apologies for that.
May please, my ladies, I appear on behalf of the fourth appellant, together with my colleague, Mr. Bram Kipido. We are ready to proceed.
May it please you, my ladies, I appear on behalf of the first appellant. Mr. Court, please.
May it please you, my ladies, I appear on behalf of the sixth appellant. We are equally ready to proceed. May it please the court.
As the court pleases, my ladies, I appear for the respondent in the matter. My ladies would have seen that we filed an affidavit yesterday, so in short, we are saying we are not ready to proceed. If need be, I will be able to put the reasons on record.
At the commencement of the hearing, we would just like to place the following procedural position on record. And it seeks clarification or verification from all the parties. And the first would be, I think you may be seated because it's going to be quite lengthy. You may rise when you address us to clarify or verify, yes.
Just a small request, my lady.
Yes.
Just a little
Okay.
bit, yes.
Okay. So there are certain procedural issues that we have identified when we were preparing for hearing today. We would like to highlight it. Please verify, clarify if need be, so that we know where we are standing with the hearing this morning. I would first place on record the procedural history. First and second appellants jointly filed a notice of appeal within the prescribed time limits, with the heads of arguments also in compliance with the directive that was given in the notice of set down. Am I correct?
Yes, we subject the confirmation of the registrar, what was agreed by the parties. Yes, we are.
Okay.
In fact, we were told on the 31st, but we
Okay.
filed on the 30th.
Okay.
Yes.
Then the third appellant,
That means
Yes.
I had only the 29th and the 30th to read the record and file arguments, and we did that.
okay. The third appellant, you filed the notice of appeal timeously,
Yes, my lady.
but the heads of arguments were out of time.
Yes, the heads were out of time, and we have lodged a condonation application that was equally called earlier.
Yes.
Yes.
We've seen the condonation application, but you know that your application for condonation is civil in nature,
Yes,
meaning that you should have filed it as an interlocutory
it was filed
on
as an
e-justice, separately, no.
Separately.
Separately from the criminal case.
Separately, and not as an interlocutory in the
No,
meantime.
it's
Yes.
correct. No, it's correct. You should have filed it as an interlocutory as you filed it. I think it was also scheduled for today.
Yes, my lady.
Yeah, yours was correctly filed.
Yes, mine is correctly filed.
So third is correctly
Yes,
filed,
ma'am.
okay,
As a copy.
okay.
You're not the culprit.
The fourth appellant, notice of appeal filed within the prescribed period.
That's correct, my lady.
It's not within the prescribed period.
That is correct, my
That
lady.
was accompanied by a condonation application, which was not filed separately as an interlocutory.
It appears that will be the culprit then, as the court indicated.
Okay, thank you. The fifth
You did file
appellant,
the condonation application.
yes. Fifth appellant filed notice of appeal, out of time, heads out of time, followed by condonation, but your condonation application was also not filed separately.
Yeah, my lady, our heads of arguments are filed out of time, So too is the notice of appeal. A condonation has been brought, my lady.
Yes.
It has been filed on the e-justice platform under the relevant case. I mean, this case
You
filed.
did not follow the ancillary process
Indeed, my
to
lady,
file
yes,
it.
that observation is
And
indeed
you
correct.
need to do that.
Yes, that observation is indeed correct, my
Yes.
lady.
Why did you file a condonation?
My lady, we have belatedly filed our notice of appeal. I believe it's,
Yes,
say,
okay.
give or take,
Okay.
8 days late.
Yes.
And our heads of arguments, I believe, are 5 days or so out of time.
Okay.
So the condonation has been brought timeously,
Okay.
my lady, although not uploaded under the ancillary process as directed by Her Lady Justice Rakau.
Okay.
Yes.
The sixth appellant. Notice of appeal filed out of prescribed timelines. Your heads also out of time. In fact, your heads of arguments application for condonation does not feature on e-justice.
My lady, it does, if I may just explain to the court.
When did you file it?
My lady, it's what I just want to explain to the court.
Yes, okay.
The notice of set down for this matter was done on the 29th of December.
Yes,
At that time, I was out of the country.
yes,
It's only my colleague, Mr. Guy, who stood in for me.
yes.
I was back on the 7th of January. So immediately on the 8th of January, that's when I obtained the record and started reading through. I was done with the heads of arguments already on the 10th of January. And I also consulted my client on that day. We filed physically through the registrar for your ladyships, that is the notice of motion as well as the heads of argument on the 12th of January.
Yes.
Yes, my lady. And if your ladyships will be able to check that on e-justice, that they do appear.
Yes, but you only uploaded them on e-justice. You did not follow the ancillary process that you should follow on e-justice.
Indeed so. That we agree, your ladyship.
We saw that we received your physical application and heads yesterday morning, and we saw yesterday afternoon.
Yes.
We saw that it was uploaded, but it should follow the ancillary process.
Indeed so, your ladyship, with regard to the notice of motion, yes, that I agree, your ladyship. That is the vote.
Okay, in respect of the respondent, the court noted that there was no notice of intention to oppose any of the condonation applications.
My lady, indeed so, it has not been filed, seeing that we filed the explanatory affidavit, which we were going to file together with the heads. By that I mean the opposition for the condonation was going to be filed together with the heads.
So you confirm that your heads are also not filed yet?
Yes, they are not filed, my lady.
Okay. What we intend to do today is that we know that we are on a recess and the computation of timelines and dates is suspended for the period of recess. We want to give directives with timelines today for all the parties who are not in compliance to file the condonation applications as an ancillary process as required by the rules. And we are going to give timelines and dates today. Those timelines and dates will not be the normal 14 days as required by the rules. The court, because bail applications are urgent in nature, would give you a shorter period of time, considering the fact that the documents are prepared already. We are going to give you 5 days, which is a week from today, for all the parties who didn't file the ancillary process to do that as required, meaning that will bring your filing of these condonation applications to a due date of the 20th of January. So except for the first, second, and third appellants, this is what will be required. We're then going to give a further date for the filing of the notices of intention to oppose, if any, by any opposing party. Deadline would be the 27th of January. A further date would be the filing of supporting documents, any answering affidavits or any affidavits that would follow on or before the 3rd of February. Then I want us to move to the second aspect. It means that we have to reschedule the hearing date for today so that we can get all these documents in order and all the filings ready for the hearing to be prepared. The respondent, on the other hand, for the filing of the heads of arguments or supplementary heads of arguments for all the parties, that we will give you a timeline after we have determined the date of hearing. We've consulted, and because bail is urgent in nature and this matter is coming on for a long time, we would want all the parties, including us as the court, to prioritize the hearing of this matter. So we have two dates that we are proposing or giving to the parties this morning. Please see how you can prioritize considering your diaries. There are no other dates that are going to be given. I want us to agree on 2 days. It's either going to be the 12th and the 13th of February this year, or the 19th to the 20th of February.
We understand that you were already, but the court is also already booked in other matters. Mr. Namanji, we have a matter that's going to continue, but this is the time that we felt we will make for this matter, seeing that it is actually something that should get preference. So even if we then stand down our other matters to deal with this matter, so that we can at least get this to a finality.
My ladies, you would have seen that my clients are not culprits in respect of non-compliance, and they have to now pay for the 3 booked days for a hearing. And I just want to place this on record. It is my clients who have been pushing this bail application, including buying printing papers for the clerk of court, because we were told one of the delays was that they couldn't print the record, and I have to convince my clients to pay something they ought not to pay for. So now, if it was open to me, and I'm just saying that in view of the fact that my clients will be, with respect of course, disappointed that the matter is not proceeding, and they have a procedural right to have their matter, an appeal being heard, and Justice Christian is correct. I mean, bail, we filed our appeal in September. This is now January already. It's really a bad state of affair. Given the situation we are in, we propose on behalf of the first and second apparent that the court imposes those first days, so that if you were to give us option to get a further date.
No, there's no option for a further date.
Yes, I think
it's only those 2 days.
Yes, I think your ladyship, although with heavy hearts, we take the 12th and the 13th. And everybody must be on terms. We will be getting explanatory affidavits all over, like we have been getting delays in the, subjected to delays in the magistrate court. You have seen the record. The issue of a medical certificate was already played around in the magistrate court.
Mr. Namanje, and this is what all the parties, including the respondent, should understand. This application will proceed on that day. We are aware of the sick certificate from the respondent. We took note of that, but at this stage, there's no proper application before court regarding that sick certificate. No application was filed. It was just an affidavit that was filed. So we're giving everybody the opportunity, because they should seek condemnation for the non-filing of their heads of argument. And this is what we're allowing them to do. But the effect of that is that you can also oppose that condemnation, and we should give you that opportunity also. So what we actually decided to do is to give everybody guidelines as how they should approach this case and get everything properly before the court, so that we can at least as soon as possible proceed with this application.
As the court pleases, I therefore propose on behalf of the first and second appearance that the court fix the 12th and the 13th of February in the circumstances.
Yes, Mr. Namanji. Mr. Kashivena?
Yes, my ladies. My lady, I think my concerns were also just canvassed between the court and Mr. Namanje. And equally, we also endorse that the court then take the dates of 12th and 13th. Personally, I have a continuation of trial the week after that. So I'm availing myself to really taking the 12th and the 13th. And as the court alluded to, my lady, we did as far as we could comply. We have filed the condonation application. I'm not sure. I have spoken to my colleague earlier. He did say he would not oppose it, but perhaps he would have a change of mind regarding the application. But in the absence of that, our condonation is before court, my lady, as the court pleases.
Mr. Isaacs?
Yes, my ladies, just one thing. Obviously, the date of 12 and 13 is, those dates are in order. I'm just worried whether or not those two dates are enough. Hopefully, I just hope that we can finish it in those 2 days.
What we decided, and this will come, Judge Christians will inform you of our decision with regard to time limits for the arguments. So, but we will inform you later on that. We just wanted to see whether the dates suit you.
Yes, I will appreciate if there's time limits for each practitioner and not argue the whole day.
As the court pleases, my ladies, it is actually important that I also place the following context in perspective. You would appreciate that the case registration occurred on the 24th of December, 2025. That's Christmas Eve. I mean, of course, compounded by the delays that Mr. Namanja alluded to that came from the magistrate's court. The notice of set down was communicated on the 29th of December, 2025. If the computation of Rule 118, sub 6 and 7 are to be properly considered, the days would start running from the date when the hearing date is communicated. So on that score, on account of the fact that the hearing date was only communicated on the 29th of December, I mean, all the parties in actual fact have a bit of a challenge in respect of complying with the time frame. But that aside, it's equally important that we place on record, your ladyships, that these dates and so forth were communicated at the height of the holiday season. Despite those challenges, when our officers had actually closed for business, we chose to uphold the mantle of justice and comply. I mean, given the shortcomings this court has now openly identified to us, we have no less substantial or partially complied given those difficulties that we were in. I mean, it was the hype of the holiday season.
We understand
Yes.
that, and this is actually what you must also bear in mind, is that actually the timelines was suspended,
Yes.
totally suspended during this period. This is why we decided to give you proper timelines that binds everybody to comply, so that everybody is clear on where we will be going with regard to the timelines.
Indeed. I hope that this consideration will be taken into account when our respective condemnations are considered. But the date 12th and 13th February are indeed in order.
Thank you. Mr. Simunia?
This is the court. My ladies, we are in agreement with the dates of the 12th and the 13th, considering that bail hearings are sui generis and urgent by nature. So we'll take those dates, and we also appreciate the fact that this court will impose timelines on each practitioner's arguments. But please, the court.
As the court pleases, my ladies, I confirm that the dates of 12 and 13 February are in order. But on a side note, on a remark that was made with regard to sick notes, I think, my lady, it's a bit insensitive to speak about sick leaves that were done in the magistrate's court, because I think no one is immortal to sickness, and I came here today to come and explain as courtesy to the court what had happened. I think I will agree with the submissions made by my colleague, Mr. Kasper, who said these dates, or the date for today and proceeding until Friday, were arranged during the hype of the festive season. And unfortunately, I was just called telephonically when I was already on vacation leave. So indeed, when one takes into account the rule of court within which each party was supposed to file the necessary documents, I think everyone else is out of time, honestly speaking, because even the heads that were filed on the 30th of December, when we take into account today's date, they were filed 9 days before today's date, and they are supposed to file 15 days before today's date, and we are supposed to file 10 days. And I think that the record also speaks for itself, that it's 4,797 pages. If one has to take into account the heads of argument, it will go to 4,963, which is quite a tedious exercise for me to have been expected to read and also reply to the heads of argument. So what I'm saying is that we are indebted to the court that it has imposed timelines to which we will comply with. Yes, as the court pleases, my ladies.
So I'll give further dates now that we have agreed on 12 and 13 February for filing of heads of arguments or any supplementary heads. For the applicants, 5 days before the date of hearing, and for the respondent, 3 days before the date of hearing. We would want the parties to please comply with these timelines. I know that the record we had to read and prepare is quite voluminous, but we have to do it in the interest of the administration of justice. As courts, we equally had to read these records during our holiday season so that we can uphold the interest of the administration of justice. So we shouldn't even bring that as an excuse to court. Your ancillary applications for those parties that did not comply. And we would also like to state that these applications for condonation and upliftment of the bar will be heard together with the merits in the main matter on the same date. So don't expect that you'll get new dates. In fact, the order that will be issued after you have filed your applications will state that it will be 12 and 13 February, and will start on the 12th of February at 9. With regards to the issue of timelines to be given and on how the parties are going to address the court, we have 2 days reserved for that. Normally in appeals, we have 30 minutes to address the court, each party. Because this matter is complicated, it's a long matter, there are issues that needs to be dealt with, we are going to give an opportunity to each party 1 hour to address the court. Remember, the heads are filed, supplementary heads will probably be filed. We are also reading. You don't need to come and rehash to us what is in the heads of arguments. If there are important aspects that you want to highlight, highlight those aspects within that 1 hour period. We're going to hear all the parties on the first day, that's the intention. On the second day, we'll afford an opportunity to the respondent to reply to the submissions that have been made. If the court has got questions to ask, we will intervene as you go. If there are issues that we want to clarify and highlight, so that we finalize the complete hearing of this matter by the second day, which will be the 13th of February.
If you need to reply, we're also asking you to limit those replies because you will have the opportunity to reply on the respondents' arguments, to limit those replies to 15 minutes. With that time period, we are sure that we will be able to fit it in within those 2 days.
Yes. Quote that on behalf of the first and second appellant, I don't necessarily think we will file supplementary hearings, but what we want to do for the court is to provide the court with a schedule with time periods and important portions of the record reference, so that, for instance, the so-called asset purchase agreement, page whatever, cross-examination of what's, just to make it easy when we argue within that hour. Instead of going back to the record, we'll just say, you end up that schedule and the schedule of timelines and important portions of the record.
That will be appreciated, yes, Mr.
As
Commander.
the court, please.
Anything else?
Nothing further from our side.
I'm
Anybody?
from fourth appellant.
None on our end, Your Ladyship.
Equally, nothing further from the sixth appellant.
None, my ladies.
Thank you. Then you can postpone it.
So the matter is then postponed to the 12th and 13th of February at 9 for hearing. The directive that we have given will be followed by a comprehensive court order for all the parties to note the timelines that were given.
As a court, please.
Thank you.